also talking about this area of law as a sort of emergent form of law, and I'm looking at the ways that FPIC is used in a particular context. My interest is not so much in what is the law, but rather in what is FPIC doing as it is articulated in local struggles. How does it frame the dynamics of local struggles or contribute to these local struggles? So FPIC, maybe I'll just use this after all. Okay. FPIC finds its origins in the International Labor Organization's Convention 169. Today it is most often cited in reference to the United Nations Declaration on the Rights of Indigenous Peoples, particularly in Article 32, where it maintains that states must consult Indigenous peoples through their chosen institutions in order to obtain, I quote, their free and informed consent prior to the approval of any project affecting their land or territories and other resources, particularly in connection with the development, utilization, and exploitation of mineral water or other resources. FPIC in South Africa, the area of my research, was first sort of appealed to in struggles starting in 2002, but really it's only been in the past, say, 5 years that advocates have really been sort of leveraging FPIC as a transnational right to consent in their struggles for control over land and territory. And I'm responding to a strain of research on FPIC that finds it to be, or argues that it represents a form of neocolonialism that defines forms of indigenous recognition, that sort of brings a predetermined set of standards to processes of consultation and consent, and that it is even a bit of a smokescreen for actual consent, and it just provides sort of a form of consultation in the context of mining projects that are happening regardless of whether or not Indigenous people say yes or no. And I'm responding to this critical literature, some of it within the field of who sort of use the governmentality framework, the Foucauldian governmentality framework, that looks at how FPIC constitutes new forms of subjectivity. And Tanya Lee, a famous anthropologist, writes very critically about actually the field of Indigenous rights generally, but also FPIC. She has a few comments on FPIC about how really it's just constituting forms of subjectivity. Peoples have to position themselves as ecological natives, or they need to fill the tribal slot in order to be recognized by the state or even corporate institutions. And I'm responding to this framework and saying, in South Africa, I should say that my research in South Africa is demanding that I take more of an open approach and I start to look at the emancipatory potential of FPIC and look at the ways that Indigenous peoples are using it, reframing it to their own ends. And I won't have my own. Okay, I'm doing okay. And I think the first thing to say about FPIC, as was said at the beginning of in the first presentation, is that it is an emergent transnational standard. It's far from settled as to what it is, the very particular rights that it constitutes, or the kinds of what a consultation process might look like, and so on. So it is very much an active field of engagement and work by a lot of different actors. So I approach it as a variable and flexible transnational standard. David Schablowski, he finds that FPIC, or he argues that FPIC represents a form of negotiated justice whereby decision-making is the result of local-level negotiations and adjudication, and it relies on horizontal forms of decision-making rather than top-down impositions of rule. And throughout these negotiations, of course, we need to pay close attention to the local specificity. Okay, we got 10 minutes? Okay. So I'm going to jump forward. In terms of technologies, I don't actually engage too much with the theories of technologies as it comes from the sort of Foucauldian tradition in this presentation because I thought maybe it was less interesting. But the idea is that, FPIC might itself be a kind of technology in the sense that it is a tool or strategy that's constituted via political processes to render particular populations legible and amenable to intervention for the purpose of shaping or instrumentalizing conduct. I think the idea of consent or collective land rights is itself a way of making legible particular relationships, and it could be seen as a kind of technology of governance. And I think FPIC could fall into that. And so, as I said, I'm trying to be more optimistic about it, working at the limits of governmentality, and I approach FPIC as anthropologists approach human rights, and they look at human rights not in legislation, but rather in the vernacularization of human rights, how people are using them on the ground, studying human rights beyond the state, focusing on local articulations, and importantly, in this tradition of studying human rights from anthropology, you look really at the work of a lot of different actors, state, non-state, local, and just very quickly, I just want to drive home that FPIC is really the focus of so many different organizations right now. We're coming up with their own toolkits, their own sets of guidelines, from the UN to NGOs, Food and Agricultural Organization, the African Commission on Human and People's Rights. They're all coming up with their new guidelines to try to lay out what FPIC might look like in a particular context. So I'm trying to look at how it's used in a specific context. Okay, so in South Africa, of course, very, very briefly, there's no time to really go over it, but basically, South Africa, there was a form of spatialized racial rule, first under colonialism, then under apartheid. People lived under particular classifications as black or colored. I'm just flying through this. But when apartheid ended in 1994, they began this huge land reform program to try to give back the land to people who had been previously dispossessed. And there were estimated 3.5 million people who were forcibly dispossessed under apartheid and pushed into reserve areas, which I'll get back to. And one of the big aspects of the land reform program was tenure reform, which is actually to secure and to legislate collective forms of tenure in the formal communal areas. Overlapping with the tenure reform program is mining governance reform, where there is still introducing legislation, and I need to emphasize that I know it's been, 24 years since the end of apartheid. So much of this legislation, although it's been introduced, it's now being amended, it's all under discussion. They're still trying to figure it out, trying to figure out what the best way is to move forward and to recognize the collective tenure rights of rural peoples and communal areas. And mining governance reform, like in the land reform, is a very active legal space right now, where they're trying to reform a mining industry that has previously and historically been in the hands of white people and try to redistribute the wealth a little bit, and then in the meantime recognize the rights, the land rights of rural peoples where mining is expanding or beginning. And an important part of this governance is the notion of territory. Territory as a way of claiming authority over land, defining the subjects that are the authorities over land, and controlling the natural resources within those territories. And this, on the left here, are maps of the apartheid reserve. So these were the areas where the black and colored peoples were forcibly dispossessed into. And in the post-apartheid period, there was the traditional leaders have really advocated for a spot in the new governance as a legitimate place in the South African governance, and for the recognition of their traditional territories that were defined under apartheid. So these are the current traditional councils of South Africa, legally recognized traditional councils of South Africa, and you'll very easily see the quick mirroring from one to the other. So a lot of people say, actually, the recognition of traditional councils today is just a re-entrenchment of laws and forms of territorial authority that originate from apartheid. So they see it as very troubling. In this context, traditional leaders have been given increased powers and authorities over land, so the land has been transferred to them over their communities, and there's many cases where traditional leaders are making deals with mining companies without actually negotiating first with the communities that are impacted by the mines in themselves. So an important aspect of this is that, you know, rural communities struggling for the rights against mining companies aren't only struggling against the state or corporation, they're also struggling against other forms, other layers of authority, including traditional leaders. I think this is really, for me, it's been a really complex dynamic to work through, because we're so often talking about Indigenous rights. We talk about this clear dichotomy between the colonized and the colonizers, and the state versus Indigenous peoples. But in this context, it's the forms of power, the relationships, who people are resisting against is much more complex than just that. There's a lot of different sub-sovereignties, I'd say. And in this context, we see that FPIC, and importantly, I wanted to say about these, in this context, communities are in a spot where they need to redefine their control and their authority over territory in a way that doesn't mirror this traditional territory system. And there's nothing right now in the South African legislation that provides a space for communities to assert, no, this is how we understand our territory. This is how we understand the authority. This is how we conduct decision makings in our area. And I'm finding in a number of cases that communities are then appealing to and leveraging FPIC as a transnational, emerging transnational right to consent as a way to sort of bring legitimacy to their claims, to say, actually, these traditional territories aren't the ultimate authorities over our land. We have our own customary systems of land tenure, of property relations, and we define them in ways that aren't recognized by the state. And one of the ways that we can bring, you know, some legitimacy to these claims and content to these claims is through the appealing to FPIC as just one aspect of their claims to living law, living customary law. So it really is a kind of articulation of an emerging claims to living law and customary law. You know, these are some quotes from an affidavit from the ongoing struggle in Kolobeni. Sorry, I didn't really explain the struggle in Kolobeni. Short of it is that there's the decades-long struggle to stop mining. There's a mining license to mine titanium. You can see in the distance there on the red sand. The mine, to build a huge mine there, and if the mine were to go ahead, you know, at least 500 people would be physically displaced, and it would, just the infrastructure from the mine and the pollution from the mine would really disrupt the whole territory. And so they've been claiming that, or in their struggles, they've really been articulating the importance of the whole territory to their livelihoods, to their culture, to their customary legal systems, their collective ways of life. This is their konkulu, their meeting place. They meet there every Thursday to discuss issues in the area. 5 different communities over a huge area. Anyway, and they really are emphasizing the collective nature of their livelihoods and their collective land tenure systems, but also their own ways of determining consent. You know, it's not simply a vote and majority wins. It's actually through very, very rigorous processes of working with different members, working through these meetings, determining how a mine would impact who, what that would look like, how someone might be compensated, and actually just maintaining peace and a sense of harmony, I guess, within their community. So they're really bringing, a huge part of their struggle is to define their own processes of consultation in terms of gaining the consent to mine on their land. FPIC, you know, I'm talking about FPIC now, or I see FPIC as just one aspect of this growing sense of living law in South Africa. I have another paper that looks at the development of living law, drawing from Aboriginal title and the famous Richtersveld decision. That paper is in social and legal studies. If you're interested in looking at this sort of, I use a similar framework. So in conclusions, in the context of legislation reform and in strategic litigation, FPIC is an important point of leverage, one strategy of legitimating the right to community consent in the context of large-scale development, in a context where rural communities aren't finding that the current South African legislation is providing the proper framework to protect their rights. It provides some legal legitimacy to new post-apartheid territorializations. So I'm talking about community-based forms of territorialization of practices, and my concept of territory anyway, I could explain that if you have questions. FPIC is emerging in these struggles, not entirely as a predefined system, not as a strict system of governmentality where subjects, for instance, are interpolated into particular subject positions in order to gain recognition from the state, but rather as an important legitimating device in the struggles for the recognition of living law. Yeah, so I hold open some hope for FPIC in South Africa, I guess.